Yes, Miss Linda.
For order. Item number 1.
My lord, item number 1 is taken up by Miss Mary, and she has some personal difficulties today appearing through VC, and the file is with her.
All right. In
If
fact,
you can-
I heard her yesterday. Somebody mentioned her child is also not well.
Yes, my lord.
So next week,
My lord.
After
As-
next week, my lord, after a week.
After week.
it is MS Linda so and so PP submits that this matter is been handled by MS Mary, learned APP, learned government advocate
Yes, ma'am.
for the state, and is presently at maternity leave, and as such seeks accommodation for a week. Prayer is not opposed. List after a week on a date to be fixed by the registrar.
Much obliged.
Item number 2.
If I may please, Your Lordship.
Yes.
My Lord, I would like to start my submissions from the brief facts of the case as per the prosecution.
Can you please adjust your microphone? Yes.
My Lord, is it better?
Yes, yes.
My Lord, I would like to start my submissions from the brief facts of the case of the prosecution story. My Lord, if I may take you to page number annexure 3 at page 24.
Yes.
This is, if I may read, the history of the case in brief is that on 23rd November 2023 at around 5 p.m., Asylum Nunfela received information from his source stating that Joinul Haq and his friends staying at Punsong were trying to receive contraband articles.
You are the you are representing serial number 1, Malsornenga.
Malsom Enga.
Okay.
Yes, my lord.
So there are total how many accused? 5.
5.
Okay. Yes.
However,
And you are who? You are the handyman or the owner?
no, I'm the truck driver.
You're the truck driver.
Yes.
All right. Please.
The handyman was also discharged by the case IO. And
handyman
charge-
is discharged.
yes, by the case IO, and charge is not framed against him. And the other 4, accused number 2, 3, 4,
Yes.
and 5,
Yes.
are discharged by the Honorable Trial Court
Trial court has already discharged them.
Yes.
So now the trial is proceeding only
against you.
You,
Yes.
the owner of the truck driver.
Yes.
Okay.
Because even
What is the status of the trial?
the trial is at prosecution evidence, and there are 8 witnesses, and 4 have deposed.
Examined.
Yes, examined. And however, my lord, like prosecution witness number 1.
Why is the why the handyman and the accused co-accused 2, 3, 4 have been discharged?
Because there is lack of evidence, and
And what is the evidence against you as per this complaint or the charge sheet?
because the seizure was from my truck, because it's a commercial truck, and we did not have knowledge about that.
One sec, you tell me your defense, but first just let me understand what is available, if there is anything available on record
Yes.
against you, because
Yes,
you are saying that because of non-availability of any incriminating circumstances against co-accused 2, 3, 4, 5, they have been discharged by the trial court at the time
ma'am.
of framing charge.
Yes, ma'am.
Right?
Yes.
And against you, so I want to know, first of all, you are the owner of the truck, you said?
Yes.
The
my lord.
driver.
I am the driver and the owner.
You are driver
And the owner.
the owner, and it's a commercial truck
It's a private registered. However,
used for commercial purposes.
yes, we transport parcels
Okay.
and goods.
Parcel and goods. Yes, and from this truck, the contraband articles have been seized.
Yes, my lord. That is the parcel is owned by Mr. Joinul Haq, and
One second, contraband articles. And these articles were inside parcels,
Yes.
which according to you has been
It belonged to, it was the parcel which was dispatched from Champhai to Aizawl. And the consignee is Joinul Haq and Majibur Rahman.
that is number 2 and
Number 3.
3.
Accused number 2 and 3.
Then how come accused number 2 and accused number 3 have been discharged?
Exactly, my lord. Because there are a lot of technical loopholes.
You please have a look at that, Ms.
My
Linda.
lord, they are just the supposed purchaser.
Whatever, that itself is an allegation. How can that be discharged?
My lord, they have not purchased yet, so it's difficult to prove the case.
No, but then apparently the truck is used for transporting delivery items. So
Yes.
inside the parcels which have been booked from one of the accused 2 or 3 it contains the contraband articles, and
Yes.
they appears to have been discharged. If you see, this is not a private vehicle, it's a private vehicle but used for a commercial purpose. If Mr. A books a parcel for delivery to Mr. B, how can the owner or the driver of the truck be held to have conscious possession of that contraband?
He was the
article?
one transporting and he was the one in possession.
Yes, but because that is his business, if I have understood correctly, it appears that he uses his truck for delivery purposes.
Yes, my lord. And he is
Correct.
the driver, so he is
Yes.
aware of it, my lord. He was the one who was transporting.
Looks vague.
My-
Anyway,
Yes,
let
that
me-
the seizure witnesses have also stated that the truck is full of parcels, different parcels containing methamphetamine or
Caesar,
not.
those depositions
In the depositions of the seizure witness, which I have annexed, my lord, that I will come later on.
Caesar witness. There are many parcels.
Yes, my lord. The truck is full of parcels, different parcels belonging to different people.
All right. Yes.
And the next seizure, which happened on 28/11/2023, also belonged to accused number 4 and accused number 5.
They have also been discharged.
Yes, they are also discharged. And also, especially the second seizure, as per the seizure memo, it was not even seized from my truck. It was seized from the Office of the Excise and Narcotics. That is how
Which one?
the second seizure, that is 3.952 kgs of methamphetamine. As per the seizure memo, which
Okay.
we will come later on,
Yes.
my lord. And my lord, I had also the discharge order.
Yes.
The discharge order is, I have annexed that as well, my lord. It's at page 67, annexure number 6.
60.
7.
What is the quantity here?
There are 2 seizures. The first seizure is,
Huge. Is it?
yes, 2.954 kgs.
2.95.
Yes, that is 30,000 tablets of methamphetamine. And 5.172 kgs of crystal meth.
And
And the second seizure is 3.952 kgs of methamphetamine kept in 4 parcels.
wait. Ms. Linda, what is there against the petitioner? Except that the petitioner is the owner of the truck and the driver of the truck. Because it has come out, it appears, she has also referred to the Caesar witness's deposition, that this truck is used for delivery of items. Now, you tell me from your own conscience,
My lord,
If-
he was the one who
whether,
was driving.
no, as a layman you tell me, Ms.
Yes,
Linda.
my lord. He was the one who was driving and he was the one who had procured the seized articles from Champhai. And he was the
Correct,
one who was
because they were in a
transporting.
packed condition. They were given to him for delivery. Is
No, my
there-
lord, no, my lord.
No, because why I
He
am
was the one
asking-
who was buying and transporting, and he was
From
the
where?
one.
Show
my
me.
lord, from page 26. This is the charge sheet.
page 26.
Yes, my lord.
Which part?
From bottom, last second paragraph.
On 21.
On 21/11/2023, the accused Mal Som Eng procured the seized crystal meth and meth at Zokothar, Champhai district, Mizoram. On the same date, he transported the seized articles from Zokothar to Aizawl by means of the seized vehicle.
No, this only says it was seized from the accused so-and-so procured. Which is procured.
Yes.
The word is procured.
He was the one who was driving the truck from Zokothar to back to the place, my lord. So he was the one who was buying, and he was the one who was supposed to sell this meth to the other co-accused, my lord. We'll come to see at page 27. Page 27, the second last para, my lord.
Yes.
My investigation therefore proved that the accused Mal Som Eng possessed and transported psychotropic substances, that is crystal methamphetamine. The accused Joinul Haq and Mujibur Rahman attempted to possess and buy psychotropic substances. The accused Christine Nunmoy and Kam Lian Thang also attempted to possess and buy psychotropic substances. So, my lord, he was the one who was selling it. And the other four are just the buyers, the intending buyers. They have not bought it yet.
Yes, you can.
If I may allow to reply,
yes,
my lord, to that.
Yes, you finish your submissions.
My lord, it's an allegation. And then he was in excise custody and he was tortured. And even the previous one was tortured. And then he was made to say yes, 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 until and unless they say yes, and they keep beating. And that is the reason. And also, this is as per Evidence Act of Section 25 of the Evidence Act. And this is recorded by a policeman as per Section 67 of the NDPS Act, which is not admissible as evidence. And apart from that, there is no evidence against me. And if my lord, I will take you later on to the deposition of the seizing officer. And that also he had stated that I don't have any documents or evidence against the owner driver apart from the seizure of that.
Sorry?
Apart from the seizure.
I didn't get your last part of the submission.
My lord, in the deposition evidence of the seizing officer, which I have annexed here, the seizing officer has said that he does not have any documents on records or evidence against the applicant, my client, who is the applicant.
But you see, ma'am, you have to appreciate that this is not the trial court.
Yes, my lord.
Correct? I am only considering whether the petitioner is entitled to be enlarged on bail or not. The offense that is involved is of NDPS Act.
Yes.
The offense that has been alleged is 22C. Rigors of 37 are there, correct?
Yes,
Now, whether what is coming out, how to appreciate these evidences that have come before the trial court, this is not the stage. The trial is yet to be completed. All I need to see is that from the charge sheet and all, whether there is some materials at this stage which indicates that the petitioner may perhaps be guilty, correct?
Yes, my
Now
lord.
it appears
Exactly.
that these contraband articles have been seized from the truck which is owned by and driven by the petitioner. That itself is sufficient. Now whether there has been procedural violation, compliance, not compliance, these are matter of facts which has to be taken up at the stage of the trial.
Yes, my lord.
In fact, you had submitted case laws. Justice Chandrachur's decision there is precisely to this point, because a presumption is also drawn here in these cases, correct?
Yes, presumption is there. However, my lord,
Yes,
while granting bail,
and the quantity is large.
quantity is large.
One cannot overlook all this. You see, you may have a very good case at the end of the day during trial, after the trial is over, but this is not that stage.
Yes, but my
The
lord,
trial is yet to complete. You have to appreciate that. I fully appreciate your hard work and everything, but Ms. Counsel, you have to understand the limited jurisdiction that this court is now exercising. Undoubtedly, Article 21 is there, but vis-a-vis Section 37 of the NDPS Act.
yes, my lord, I'm coming to that as well. Section 35 and Section 37 as well. My lord, I have case laws on that to support my
I
claim.
have seen all your notes.
And
which
also,
you
my
have
lord,
submitted.
Justice Chandrachud has also said that while granting bail, the court does not have to pass an order of acquittal Or-
Absolutely.
Yes,
You see,
it's not like,
the bail code is not a conviction code.
yes, my lord.
But at the same time, that's why I'm saying your case is different from the normal bail court cases, because here you're concerned with the NDPS Act.
Yes, my
The
lord.
offense alleged is 22C,
Yes,
correct? And you cannot deny the fact that you were not driving the truck. You were driving the truck. The truck belongs to you. These contraband articles of large quantities have been seized from the truck. You are trying to make out a case that one or two of the co-accused have booked these purses and you have transported. But the prosecution story is that you have procured them. Now you see, I cannot go into the veracity of these allegations. I am not testing whether these allegations are true or not true. Am I testing that?
yes, my lord.
I am not testing that. I am not reappreciating the evidence at this stage. All I have to see is that if there are materials,
That if there are materials against me,
so
then
that cannot be oversight.
that, my
Right.
lord, that
Anyway, for your satisfaction, please sum up your submissions. But I don't think.
That, my lord, the conscious possession has to be proved by the prosecution, a foundational facts in the chain of events incriminating the accused has to be first proved by the prosecution in order for the section 35 to be applicable against the applicant. It's a presumption of culpable mental state. And that is where section 35, the embargo of section 37, which does not grant bail. I mean, in a short way, I'm saying it. That's how that it stems from section 35. And that, my lord, the prosecution has not set up a case against me or an evidence. And therefore, the burden of proof against me has not shifted. And that, my lord, I have supplied a Supreme Court ruling on that. And that is also a division bench, not just single bench.
Yes.
And also, my lord, when it comes to conscious possession, even though the recovery was from my possession, if it is of not conscious possession, then it cannot be as per section 35. Section 35 is not applicable. So if section 35 is not applicable, then the rigors of section 37 does not apply at the time of granting bail. And also my lord, we are HIV positive, and that I have also submitted the Supreme Court ruling that HIV patients bail should be disposed. And
Well, that's not in the context of an NDPS.
however, my lord, that the principle,
And there is no such precedent that if a accused is HIV positive, he has to be enlarged on bail. That can't be a.
yes, that can't be, but
that
considering
cannot be
all,
a principle of law.
yes,
You see, the decisions of the apex court and of other high courts, these are all contextual. You have to apply them in the context it is delivered.
yes, my
Those
lord.
decisions, except one, are all after conviction, after the trial, not on bail. For bail, you have given just one, I think. This,
Yes, my
the
lord.
Union of India, Nawaz Khan, CJI's decision.
Yes, that
Yes.
in that, my lord, if I may take your lordship to para 22 regarding the conscious possession.
Before you go to para 22, come to para 12.
Para 12. Yes, my lord.
Yes.
Para 12.
These are the facts of this particular case. And in fact, in this case, the High Court had granted bail, which was cancelled by the apex court.
Yes,
Now,
exactly.
kindly see the facts.
At the present stage, it is material to know that the vehicle which was intercepted at Lucknow was proceeding from Dimapur, Nagaland towards Rampur, Uttar Pradesh. The quantity of 3.3 kg of narcotic substance,
300 kg.
no, 3.3 kg.
3.3.
Yes, my lord.
Okay. Yes.
which is a commercial quantity, was found concealed in the vehicle. Number 3, the respondent is not an unknown passenger, but a person who, according to the prosecution, was closely in contact with the accused. That, my lord, the facts in this case, in this particular case,
Now you
the
come
applicant...
to 18.
Under section 37(1)(b) subclause B, Roman number 2, the limitations on the grant of bail for offences punishable under sections 19, 24, and 27A, and also for offences involving a commercial quantity are: the prosecutor must be given an opportunity to oppose the application for bail. There must exist reasonable grounds to believe that a person is not guilty of such an offense. That, my lord, we have completed that. We have
Sorry.
that the reasonable grounds.
This court doesn't accept that submission of yours because the contraband articles have been seized from the truck that you were driving and you own that truck. How can you say that you did not have possession? It was you were the
That-
one who is driving that truck.
That, my lord, that is also, we don't know whether it was seized from me.
Those are now matter of facts, Miss Counsel. That's what I'm trying to tell you.
That is there, my lord, but
this will come during trial. All
That-
that. But as at this stage, there is no
That
running
is
away from the fact that these contraband article of huge quantity have been seized from the truck.
That, my
Correct
lord,
or not
that is the
correct?
point what I'm trying to
Yes,
make
yes,
here, my
yes.
lord. The thing is that if section 35 and section 37 applies to me, I have just mentioned that it does not apply to me because the presumption of culpable mental state. If the presumption is not there, then the
Why are
prosecution...
you saying the presumption is not there?
Because as per, my lord, as per the Supreme Court ruling, and as per looking at the facts and the material available on records by the prosecution, there is no chance of a conviction, and also...
Sorry.
And also, my lord, and also, we don't know whether that contraband was seized from me or not. Because we
This
don't even know, because there are...
This decision which you are citing is only against you.
It's not against me, my lord. In this case as well, it is not recovered. The contraband was not recovered from him. And my lord, the judges, the honorable judge has made a decision that even if it's not recovered from him, there is conscious, there is...
All right, read para 22. You wanted to read para 22, right?
Yes, my lord.
Read.
We shall deal with each of these circumstances in turn. The respondent has been accused of an offense under section 28 of the NDPS Act. My lord, this is not relevant.
No, it is relevant.
In Madan, it's
Yes,
this one.
the concept of possession reoccurs in section 20 to 22, which provides for punishment for offences under the Act. In Madan Lal, then you read para 19 from
Yes. Whether there was conscious possession has to be determined with reference to the factual drop. The facts which can be culled from the evidence on record are that all the accused persons were traveling in a vehicle, and as noted by the trial court, they were known to each other. In my case, they are not known to each other, and there is no CDR record that they have been like contacting each other. There is no corresponding CDR analysis.
In your case, there were other passengers.
The handyman was there. The handyman was discharged.
The handyman was there,
Yeah.
but the driver is there. Yes, continue reading.
And it has not been explained, or shown as to how they traveled together from the same destination in a vehicle which was not a public vehicle. Section 20B makes possession of contraband articles an offense. Section 20 appears in Chapter 4 of the Act, which relates to an offense for possession of such articles. My lord, here Section 22 also appears in Chapter 4 of the Act. It is submitted that in order to make the possession illicit, there must be conscious possession. It is highlighted that unless the possession was coupled with the requisite mental element, that is the conscious possession and not mere custody without awareness of the nature of such possession, Section 20 is not attracted. Here, in this case, my
Please
lord,
continue reading.
the expression possession is a polymorphous term which assumes different colors in different contexts. It may carry different meanings in contextually different backgrounds. It is impossible, as observed in so-and-so, to work out completely logical and precise definition of possession uniformly applicable to all situations in the context of all statutes. The word conscious means awareness about a particular fact. It is a state of mind which is deliberate or
This
intended.
26 is important. Once possession is established, the person who claims that it was not a conscious possession has to explain it.
Yes.
Because how he came to be in possession is within his special knowledge. Section 35 of the Act gives a statutory recognition of this position because of the presumption available in law. Similar is the position in terms of Section 54, where also presumption is available to be drawn from possession of illicit articles.
That, my lord.
Now you read. What amounts to conscious possession?
What amounts to conscious possession was also considered in Dharampal Singh versus State of Punjab, where it was held that knowledge of possession of contraband has to be gleaned from the facts and circumstances of a case. The standard of conscious possession would be different in case of public transport with several people as opposed to private vehicle with few persons known to one another.
Here is a private vehicle.
Yes, it's a private vehicle, but we are not known with the alleged.
It's a private vehicle, ma'am. This is not a public vehicle.
Yes, it's not.
Yes. Yes, continue reading.
And they were not known to the other co-accused, my lord.
These are your explanations.
Yes.
This will come during the trial.
But my lord,
I
But I'm
understand
tr-
your anxiety. But you see, we are also bound by the
yes,
law.
my lord, at least let me finish my
Yes, I will
whatever
allow
I've
you
prepared.
to finish. I've been patiently hearing you.
Yes, thank you, my lord.
Yes.
In Mohanlal versus State of Rajasthan, the court also observed that the term possession could mean physical possession with animus, custody over the prohibited substances with animus, exercise of dominion and control as a result of concealment, or personal knowledge as to the existence of the contraband and the intention based on this knowledge. That, my lord, my submission is that there is no conscious possession. As per
Yes, I'm not-
and my lord,
According to you, the owner had no idea what that those parcels contained.
yes, my lord,
This is your submission, right?
and which is evident from the evidence which has already been taken in the seizing officer as well as the seizure witnesses. And my lord, there is another citation that I would like to quote.
Which one?
2023 live.
Which one? This is on which point?
My lord, para 15 and 16. I've written in
Yes,
the
yes, I've
upper
got
one.
it. This is presumption, 35.
Yes, my lord.
Yes.
Initial burden.
Yes.
My lord, if I may take your lordship to para 15 and 16.
Yes, you have already said, according to you, by relying on this decision, the actus reus cannot be held against the accused and burden of proof does not shift to accused in absence of mens rea. This is what you want to show?
Yes, my lord.
He had a knowledge that he carried parcel, certainly. He had no knowledge about carrying the parcel containing contraband. This is what you are saying.
Yes, my lord. I'll just, if I may just read few
Para 15,
sentences. Yes.
please.
Para 15 and 16.
Yes.
We may first test we may first test on the anvil of settled law the plea taken by the learned counsel for the appellant, so and so, that the prosecution had failed to establish a prima facie case against the accused, and therefore the burden of proving his innocence did not shift back to him. In the case of Noor Aga, a two-judges bench of this court was required to decide several questions, including the constitutional validity of the NDPS Act and the standard and extent of burden of proof on the prosecution vis-a-vis the accused. After an extensive discussion, the court upheld the constitutional validity of the provisions of Section 35 and 54 of the NDPS Act, but went on to hold that since the provisions of NDPS Act and the punishments prescribed therein are stringent, the extent of burden to prove the foundational facts cast on the prosecution would have to be more onerous. The view taken was that the court would have to undertake a heightened security test and satisfy itself of proof beyond all reasonable doubts. Emphasis was laid on the well-settled principle of criminal jurisprudence that the more serious the offense, the stricter would be the degree of proof, and a higher degree of assurance would be necessary to convict an accused. That, my lord, they have not done that. And there are a lot of rules which are not followed. And we don't even know whether the contraband was seized from my truck. And if I may continue, my lord. And my lord, I had given a citation which says that the rules of the NDPS of 2022 is mandatory as well.
Matter of
And my lord,
trial.
yes, my lord. If I may continue, para 16. Thus, it can be seen that the initial burden is cast on the prosecution to establish the essential factors on which its case is premised. My lord, this is not very... Okay, after the prosecution discharges the said burden, the onus shifts to the accused to prove his innocence. However, the standard of proof required for the accused to prove his innocence, my lord, this line is very important. However, the standard of proof required for the accused to prove his innocence
At the time of bail.
is not packed as
Yes. Is this at the time of the bail?
at the time of the trial. However, that, my lord,
So you see, this is not a convicting court. The
That's-
decisions that you are trying to rely, these are all decisions post-trial.
yes, my lord, that is the point exactly what I'm trying to make.
Anything more? I have
Ye-
given you a lot of time. Please now
Here, my
make
lord.
submissions only which are pertaining for consideration of a bail in NDPS matter.
Yes,
Nothing
my
more
lord.
than that.
If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35, the actus reus, which is possession of contraband by the accused, cannot be said to have been established. That, my lord, Section 35 and Section 37 does not apply. So in that case, my lord, we are presumed to be innocent at this stage. So we are eligible to be enlarged on bail.
All right.
As per my humble submission, my lord, and the learned PP has stated that there is incriminating evidence against me, and which is not acceptable, which cannot be used as evidence in the court. That, my lord, I don't have to put the citation, right, my lord. And rule.
All right, you have submitted some procedural rules have been violated.
Yes, procedural rules have been violated, and my lord.
You see, I am telling you, this is a discretion that I have to exercise.
Yes, my
right?
lord.
I am not on non-compliance of those rules because these are matter of trial. They are factual aspects. The trial is not over. So I have taken note of your submission.
And also,
I will deal
my lord,
with it.
the trial will be still long because the seizing officer is also the arresting officer in the second seizure as well. So, and
According to
FSL
you,
also,
trial
there are
will take
two.
some more time.
Yes, it will take some more time. And also, my lord, if I may just read one thing. However, any guideline issued by way of notification in consonance with Section 52A of the NDPS Act has to be followed mandatorily, my lord. That I have submitted. And also, my lord, he is not he's not a drug trafficker because he had taken on loan. If he was rich, then why would he have taken on loan? Just like
These are
15 lakhs.
factual matters. Why?
Yes, my lord. That,
You
and
see,
also,
you have to understand. You see, first of all, you have to be mindful as where you are standing, right?
Yes, my lord.
Judicial time you are taking. Now, please be confined to the factors which are relevant for consideration of a bail.
Yes,
This
my
is
lord.
not a convicting court.
Yes, my lord.
Don't convert the bail courts into a convicting court and start submitting submissions which are pertaining to the factual aspect of the matters. How can this court decide or appreciate?
That
Trial is going on.
My lord, in my humble opinion, that is necessary and relevant because the embargo of sections 35 and 37.
All
of
right,
the-
I've given you sufficient hint.
And also, my lord,
Yes.
he has 2 children, and
All right.
they cannot. And he has some
Anything
medical
else?
problems. Medical problems.
Anything
as
else?
well. No, my lord.
All right, you may take your seat. Yes, Miss Linda.
My lord, the learned counsel has submitted that trial will be going on, but my lord, I have information from the additional PP from the district court that there's only one witness left.
So out of 8, only 1 is left.
Yes, my lord, and he has been summoned on 25/9 of this
1 left, and he is summoned when?
25th of September.
Okay,
So trial will be complete very soon, my lord.
all right. And otherwise, anything antecedent?
Antecedent, my lord,
Adverse antecedent?
from the
No, my lord. No, my lord.
petition which I've seen, my lord, nothing can be found out.
All right. But so your case is that these contraband articles of large quantities have been seized from
his truck.
from the truck which he was driving.
Yes, my lord.
And on that basis, the entire case is built up.
And on the basis of that, my lord, we have arrested 5 persons. But after going through the trial, my lord, the learned trial court has applied its mind and discharged all the other accused except this one, who is the main accused.
From the evidences that has come on record,
Yes, my lord.
anything that has come against the petitioner?
My lord, it's proof that this seized article was seized
Can
from
you please
this
take
truck.
me to the relevant portion?
PW number 1 is at page 73.
One second. Page?
73, annexure 7.
Yes.
At para 4, my lord, self and my party left to the reported place, Punjong, and we were searching for the suspected Bolero pickup. We saw the Bolero pickup at Punjong near petrol pump. Just before we intercept them, they run towards Rangomwal Road. We followed the Bolero pickup as soon as we did not know where they parked the Bharat Benz vehicle. At Bongkondur Tlang Road, we intercept the Bolero pickup and we detain Joinul Haq and Mujibur Rahman. These two are the alleged buyer. And I asked them their purpose of visiting Mizoram, and they told me that they were trying to receive methamphetamine from Malsom Enga. Malsom Enga is the main accused. Mujibur Rahman telephoned the accused Malsom Enga and asked him where he parked his vehicle. Malsom Enga replied that he was staying at Falkland Vang near Puhola Park. We brought the 2 suspected persons and we proceeded to Falkland Vang. Upon reaching Falkland Vang, we saw the suspected Bharat Benz vehicle and the driver Malsom Enga. We detained the accused Malsom Enga and Malsom Kima. We escorted the vehicle to Khatla near tennis court. And they have, at para 5, they have arranged civilian witnesses and they recovered these contraband articles.
Okay.
So, my lord, possession is proved and they are booked under 22C, which is in violation of possession, transports and selling. And he is the main accused, my lord.
But I still don't understand why the trial court has discharged the others.
The others, my lord, nothing can be proved. They were just the alleged buyer. They
were
have
also-
not brought it yet.
Yes, but then they were there in the car.
They were not
They
in
were
the
not.
car.
But they said that they wanted to they purchase.
They came to buy.
They came to buy.
Yes, my lord.
So it's not that they didn't have a role.
If I-
My lord, they came to buy. We do not have any witness to prove that also. That's why the trial court has discharged them.
Anyway, but that doesn't mean that the only difficulty is that this possession has been from them. So
Yes.
guilt in 30 as per 37 seems to be
Yes, my lord.
made out. Yes, Miss Fanai,
Yes, my lord. If I
you
may.
wanted to say something?
Yes, the information was received from the co-accused, and from the statement of the co-accused, the applicant was. My lord, if I may take you to just one, the deposition of the seizing officer at page 73.
73 is the seizing officer.
Yes,
Yes.
and my lord, the cross-examination part at page 74 and 75.
Yes.
It is the fact that from the cross-examination by DL, it is a fact that from the prior information I received, Joinul Haq and his friend Majibur Rahman were to receive parcels which were sent through truck driver Mal Somyenga.
Yes.
That is there. No.
See, as of now, this is proved that, in fact, you cannot even run away from that allegation.
My lord, here at number page 75, point number 5. It is a fact that there is no incriminating documentary evidence against Mal Somyenga, such as CDR, messages, etc., apart from the recovery of the essay from the parcels carried in his commercial
What is
truck.
essay?
Seized article. The contraband drug.
Yes,
Oh,
what happened to the call data records? They were not sent.
No.
Why? But that link has to be drawn because these people have, their allegation is that they have come to buy from the driver. Correct?
Yes.
Now, if that is the allegation, then you have to show the connection between these people.
It was not shown, my lord. That is why the learned trial court has.
Then how can you show that this person has?
This person was in possession.
All right, for the purpose of bail, maybe I am not required to go into all this. But Miss Linda, at the end of the day, you have to also show, because if it has come from the seized witness that this is a commercial private vehicle, but used for delivering goods, how do you expect the driver or the owner to know the contents of each and every parcel? Unless and until you show that there is some link, the call data analysis will show. If it shows that they have been constantly in touch, perhaps. Anyway, these are, but Miss Fanai, the problem is these are matters for the trial.
also, my lord, here, number 6.
All right.
It said that the parcel belonged to Joinul Haq and Majibur Rahman.
All right.
And the second seizure also belonged to the other accused on
Okay.
records, which is evident.
Heard MS L. Fanai, give the full name, huh? Learned counsel for the applicant, stop. Also heard MS Linda, Learned PP for the state respondent. Stop. This application is filed under section 439 CRPC, read with section 37 of NDPS Act 1985 to enlarge the accused I. Shri Malswang Swamanga on bail, who has been arrested. Do you have the date of arrest? Who has been arrested on such and such date?
23/11/2020.
23/11/2023 in connection with SR number 77/2024 arising out of criminal trial number 396 of 2024 within bracket excise case number N-302-2023 registered under section 22C of the NDPS Act 1985. The case of the prosecution is the case of the prosecution is that the applicant accused was arrested by excise personnel for alleged involvement in the connection with seizure of 2.954 kgs within bracket 2.954 kilograms of suspected to be methamphetamine and 5.173 kgs within bracket 5.173 kilograms of white color crystalline substance suspected to be a crystal methamphetamine, which was seized from the vehicle of the accused applicant and was booked under section 22C of the NDPS Act. MS Fenai, learned counsel for the petitioner, submits that the applicant is the owner and driver of the seized vehicle, I Bharat Bench 1917 BR number MZ01/Z 3784, seized by the excise personnel in connection of the said case, and she further submits that the said vehicle is used for transport for delivery and transportation of goods / parcels. She accordingly submits that though the contraband articles have been seized from the parcels contained in the said truck driven by the applicant, however, the applicant had no knowledge of the contents of the parcels, as these parcels are booked by different persons for delivery to the destination, to the addresses appended in the parcels. So, she accordingly submits that there is no conscious possession and hence no offense under the NDPS Act is made out against the applicant. Stop. She further submits that the trial has already commenced. No, don't say that. She further submits that there has been procedural violation and therefore the trial is vitiated and the applicant is liable and the applicant is entitled to be enlarged on bail. She further submits that the other co-accused who has been arrested along with the applicant has been discharged by the trial court as well as by the investigating officer for non-availability of any incriminating materials whatsoever against them. She accordingly submits that the applicant in the case of applicant also there cannot be said that there is any incriminating evidence collected by the available against the applicant at this stage, and hence he ought to have also been discharged by the trial court. Stop. In support of the aforesaid submission, she submits the following decisions. Number 1, Union of India through Narcotics Control Bureau versus MD Nawaz Khan in Criminal Appeal number 1043 of 2021. Number 2, Gangadhar LS Gangaram versus State of Madhya Pradesh in Criminal Appeal number 504 of 2020. Muhammad Khalid and another versus the State of Telangana in Criminal Appeal number 1610 of 2023. Balwinder Singh versus the Narcotics Control Bureau, reported in 2023, live law within bracket SC 813. Bhavani Singh versus State of Rajasthan in SLP criminal number 2225 of 2022. Bhuta Singh and others versus State of Haryana in criminal appeal number 421 of 2021, and Mangilal versus State of Madhya Pradesh in criminal appeal number 1651 of 2023. Following, where you have said following decisions, say following decisions of the apex court. Per contra, MS Linda, Leonard PP submits that a huge quantity of contraband articles have been seized from the possession of the applicant, and as such, the bail prayer ought not to be entertained. Okay. Per contra, MS Linda submits that it has been, it has come out from the, that it is established from the materials available on record. That. Okay. Right?
Yes, madam.
I have given my prudent considerations to the arguments made by the learned counsel for the parties and have perused the materials available on record, including the citations materials on record, including the scan copy. This has come.
No.
Materials on record, and also have considered the citations submitted at the bar. It appears that the investigating team, upon receiving specific information as regards transportation of contraband articles being transported from the vehicle driven by the applicant, after recording the information in writing, proceeded to the location from where the said truck was intercepted, and the applicant, along with the handyman, were detained, and after following the formalities, a search was conducted in the said vehicle, from where, in the presence of reliable independent witnesses, the following contraband articles have been seized. Page 24, you will get it, huh? Number 1, I have tick mark. Number 2, It further appears that it further appears from the materials available on record that the applicant accused on 21/11/2023 procured the seized contraband articles at Zokhwanthar, Champai district, Mizoram, and on the same date he transported the said seized articles from Zokhwanthar to Aizawl in his truck, which was also driven by him. Stop. It further appears that pursuant to submission of the charge sheet, trial has commenced and only one prosecution witness is yet to be examined. It further appears that the said prosecution witness is scheduled to be examined on the 25th September 2024. Thus, the trial appears to be concluding shortly. Stop. In the present case, the offence being under the provision of NDPS Act apt to refer to the principles laid down by the Apex Court in the case of Union of India through Narcotics Control Bureau, Lucknow, Supra. Paragraph 18, 19, 20, is reproduced hereunder for ready reference. Reading of the aforesaid principles, apparent that the test which this court is required to apply while granting bail is to see whether there are reasonable grounds to believe that the accused has not committed an offence and whether he is likely to commit any offence while on bail. Stop. Undoubtedly, given the seriousness of offences punishable under the NDPS Act, stringent parameters for the grant of bail under the NDPS Act have been prescribed in order to curb the menace of drug trafficking in the country. In the present case, it is material to note that the contraband articles of huge quantities have been seized from the truck owned and driven by the applicant. Stop. Though MS so-and-so Fenai, learned counsel for the applicant, had argued that the applicant had no knowledge of the said contraband articles, and as such he cannot be said to have conscious possession, cannot be accepted in the facts and circumstances of the present case. Stop. Section 8 of the Act prohibits a person from possessing any narcotic drugs or psychotropic substance. Section 20B makes possession of contraband articles an offense. Section 20 appearing in Chapter 4 of the Act relates to offences for possession of such articles. The expression possession has to be understood in the context of awareness about the particular fact. And once such awareness is established, after that, and it is well settled that once possession is established, the person who claims that it was not a conscious possession has to establish it, because it is he who knows how it came to be in his possession. Stop. Section 35 of the Act gives a statutory recognition of this position because of the presumption available in law. Similar is the position in terms of Section 54, where also presumption is available to be drawn from possession of illicit articles. Reference is made to paragraph 22 of the aforesaid decision of the Apex Court, which is hereunder reproduced for ready reference. Be it may be stated herein that the trial is yet to be completed, wherein all the evidences will be adduced. What cannot be overlooked at this stage is that the applicant has been was caught with the seized contraband articles, which establishes possession at this stage. Hence, by applying the rigor of hence it appears that there are materials to indicate that the applicant is guilty of the offence alleged. Therefore, considering the facts and circumstances of the case, and by keeping the rigors of Section 37 of NDPS Act in mind, this court is not inclined to grant bail to the applicant at this stage. As such, the bail application stands rejected. Sorry.
Yes, my lord. My lord, if this may be reflected as well, the page 75, my submissions.
Page 75.
Yes.
That is part
Point
of the
number
evidence.
6. Yes, my lord. This is what I have referred to.
No. What is from 75? That cross-examination part?
Yes, point number 6, page 75 at point number 6.
All right. On.
It is a fact that the
All
three
right.
parcels.
All right. I've
contain-
understood.
Yes, ma'am.
Where you have you just put a star and write it. You fit it in during after the last submission of Ms. Fanai. Okay. She further submits that from the cross-examination of the who is this person?
Seizing officer.
Of the seizing officer, it appears that there is no incriminating documentary evidence against the applicant, such as CDR, messages, etc., apart from the recovery of the seized articles from the parcels carried in his commercial truck.
No, my lord.
It is
So,
there.
number 6. That is number 5. Point number 6.
All right, that also you had given. And,
This is a proof that we don't have conscious possession.
she further submits that the co-accused were trying to receive the parcels from the accused No, this is not required. All right.
My lord, that is.
This is a matter of evidence, Miss Fanai.
Yes.
You are an officer of the court. You must understand what and how much you will submit also. These are matters of appreciation of evidence. How can a bail court go into all this? It's a part of the cross-examination where a suggestion has been put. Can on that basis a bail be granted, Miss Fanai? That too in an NDPS case. You have to appreciate the bounds within which this court also has to act, isn't it?
Yes, my lord.
Anyway, I appreciate fully your effort. All right.
Oblige.
For hearing item number 3.
My lord, due to the paucity of time, this matter can be adjourned and maybe to another bench.
And my lord, we have checked the case record yesterday, and there seems to be quite a lot of these defects and missing evidences.
What is to be done then?
My lord, if the registry may be directed to see with the actual records and see the paginations.
All
and
right.
That
This MAC appeal was partly heard yesterday, 12/9/2024. And after noticing that there were some illegible documents available in the case in the photocopy of the case records, right? That is
my lord.
that's a scan copy.
Yes, my lord.
Scan copy.
Scan
Scan
copy of the case records from the MACT tribunal. MACT, which tribunal?
Aizol.
Aizol.
Both parties were requested to inspect the case records. Stop. Today, when the matter was called, it is submitted at the bar that there are large number of defects appears to be there in the said scan copy of the case records. Stop. Unless the defects are rectified, the hearing cannot proceed, and as such, it is released. This case is released from part heard. Stop. Let registry verify the case records and rectify the defects so as to enable the court to take up the matter for hearing on the next date of listing. List the matter after 4 weeks on a date to be fixed by the registry.
Obliged.